Live stream started.
இன்ட்ரோ கொடுக்கலாமா? ஹலோ
இன்னும் சார் 6 நிமிஷம் இருக்குல்ல சார். இன்னும் 6 அப்பதான் வருவாங்க. 6 வந்த நாள் பேச ஆரம்பிச்சாதானே.
இது அப்படியே கேக்குது அப்படியே.
நீங்க இது பண்ணிடுங்க. உங்களுக்கு எதுவும் நீங்க அவசரப்படுறீங்க. வீட்டு இன்ட்ரோ கொடுக்கலாம்னு.
எக்கோ அடிக்குதுடா
சுரேஷ் சார்.
ஓகே.
நீங்க இந்த அசோசியேஷன் பேர் என்ன? மெட்ராஸ்
லைப்ரரி அசோசியேஷன்.
லைப்ரரி ஆரம்பிச்சது எப்போ?
அது எப்படா? 1930 சார். 32. ஏனது
1928
சார்.
1928 by whom?
டாக்டர் எஸ்.ஆர். ரங்கநாதன்.
எஸ்.ஆர். ரங்கநாதன். ஃபாதர் ஆஃப் தி லைப்ரரி.
ஆமா, அவர்தான் ஆரம்பிச்சார்.
4 ஸ்டேட் உண்டா? கேரளா.
ஸ்டார்ட் பண்ணலாம். கொஞ்சம் அமைதியா
இருங்க.
ஃபேன் சவுண்ட் கேக்குதா உங்களுக்கு?
இல்ல, கிளியரா இருக்கு.
ரைட், ஓகே. சார், ஹலோ
சார். நான் கூப்பிடுறேன் லைவ்ல.
சுரேஷ் சார்.
திருநாவுக்கர் சார்
சார்
எக்கோ அடிக்குது நீங்க பேசுறது. நான் கேட்க சரியா கேக்குதா?
நீங்க பேசுறது கிளியரா இருக்கு.
சரியா? இது ஒரு
ஒருவேளை நீங்க யூடியூப் எதனா ஓபன் பண்ணிருக்கீங்களா?
இல்ல ஒண்ணுமே இல்ல. வாட்ஸ்அப் ஆஃப் பண்ணிடுவா.
ஆஃப் பண்ணிடுறேன்.
சரி ஓகே. இப்போ ஒரே ஒரு சின்ன இது எவ்வளவு நேரம் போகும்? ஒரு 3/4 மணி நேரம் போகுமா?
நீங்க சொல்ற டைம் தான். நீங்க எவ்வளவு பேசுறீங்களோ அவ்வளவுதான்.
சரி அது இப்போ ஒரு 1 GB போகுமா நமக்கு? ஏன்னா ஏர்டெல் மாத்திரம் தான், ஏர்டெல் மாத்திக்குவாங்க தான் கேக்குறேன்.
இல்ல அதுக்குள்ளதான் வரும்.
அதுதான் இது 2 இல்ல ஜியோல 2 GB இருக்குது.
ஸ்டார்ட் பண்ணலாமா? சரி
ஸ்டார்ட் பண்ணலாம். நான் ஸ்டார்ட் பண்றேன். நீங்க வந்து அப்ப இன்ட்ரோடியூஸ் பண்ணுங்க.
சரி ஓகே.
Good evening to everyone. I welcome all participants for Lisquiz.com and Madras Library Association webinar series. This is the 5th session. I invite Mr. Suresh to introduce our resource person.
Okay.
Suresh sir.
Good evening to all. Today our resource person Mr. N.GOWTHAMAN, Assistant Professor, Crime and Tort, Government Law College, Chengalpattu, Tamil Nadu. He is also academic board member in Tamil Nadu Open University, examination board member in Central University, Pondicherry, and Tamil Nadu Dr. Ambedkar Law University. He wrote 4 books. He presented 38 conference papers. He published 4 international articles in international reputed journals. In the year 2001-2004, he was practicing advocate in Madras High Court. He recently delivered a lecture on webinar series in Vallalar College, Erode, on the topic of Cyberlaw. Once again, I welcome you, sir. Today's topic is Cyberlaw and social media. Let's section hand over to Mr. Gowthaman, sir. Once again, I welcome you, sir, on behalf of Lisquiz.com and Madras Library Association and his participant. Welcome you, sir.
Okay. Good afternoon, everyone. That is privilege to thanks everyone to the Madras Library Association, especially Professor Librarian of Tiruchirappalli Law College, Mr. Suresh at Tirunavakar. I heard that Madras Library Association started in the 1928 by Mr. S.R. Ranganathan, father of the library science. That is a great opportunity to participate with you, share my ideas and related issues on the social media and cyber law. That is a day, 29th May 2020. Friday is a good Friday because of hot summer is over yesterday. So that is a pleasant Friday. So we will discuss today in the topic of social media and cyber law. Before the seminar or presentation, I am the one of the member of your society. I mean, society means it is not a registered member. I am a one-day librarian in my primary library in Thuthukudi district, Udangudi. So I am the family I am a member of your family, librarian family. Once again, I welcome to everyone. Welcome to all. That topic is very peculiar topic. Social media and cyber law. First, we will discuss about what is the social media. Before this introduction of social media, I elaborately discuss about the media. Right to speech and expression. That is fundamental right ensured by the Indian Constitution under the Article 19. It is not only the fundamental right, it is a natural right, because a right to speech or expression is not a conferred by the constitutional law or fundamental right or Article 19. In every child, in his breath, first breath taken by the vocal cord through over the nose and mouth, that is a crying. So that is a right to speech, the initial stage of right to speech. So that is naturally we have a right. Every human being have a right. That is ensured by the Article 19 of the Indian Constitution. So it is not given by the Constitution. It is ensured by the Constitution. That is different is that. Right to speech and expression is conferred by the Article 19, subclass 1A, small a. Why we will speak the Constitution? Please understand. 19 subclass 1 and subclass A is ensure the right to speech, not only speech, expression also. I have speak with you, sometimes my hands, eyes, or speak with you with body language. So that is also considered as expression. So we will see in so many films and TV serials. So the body expression, movement is also speaks his expressions. So the faces like speak the more than the mouth. So Article 19 subclass 1A ensures the fundamental of right to speech and expression. But at the same time, Article 19 subclass 2 introduce the reasonable restrictions. Some restrictions against the this fundamental right to speech and expressions. The reasonable restrictions is regulated by the criminal laws. In the same time, we will consider the another part of the Constitution that is called right to know, right to knowing. It's not a fundamental right. It's a legal right. You know very well the law. You are a librarian, so not only the librarians. You are a library science and library and information science. You are an information scientist. Because of a right to know is not a fundamental right earlierly. Now that is a fundamental right. How it is possible? Very clear. A right to Information Act 2005. You know very well. It's a central act. The act passed by the central government in the year 2005. Earlierly, our Tamil Nadu government is a very good legislation in the 1997. Right to Information Act 1997 is the state level. But 2005, eradicated of the all state level legislation in the right to information is a unanimous legislation introduced throughout the India. So the Right to Information Act give a right to the people to inform or understand or knowing anything through over this legislation through some proper channel. You get a 10 rupees fees and getting application and getting anything from the public office, not a private office. So it's a fundamental right. It's not a fundamental right. It's a legal right, like a right to vote. Right to vote is only the legal right because of People Representatives Act 1951 news. You have a right. Otherwise, you have no right. As per the legislation, 21 years earlierly, 21 years, whole young chaps have a right to vote. Then later it is reduced to 18. As the same thing, a right to knowing is a legal right through over the legislation, namely Right to Information Act 2005. Later, our Supreme Court give a decision. The right to know or knowing is not only the legal right; it's a fundamental right. It's a part of the article right in Article 21. Article 21 is a right to life and liberty. Right to life and liberty include a right to knowing. Because of you give sometimes there is a corona period, doctor give a medicine good to the patient. Patient asking to the doctor, what is the name of the medicine? What is the content of the medicine? Everything is asking by the patient to the doctor. That is a right ensured by the Article 21 because of right to life. Your medicine, your content of the medicine, dosage of the medicine, everything is affecting my life. So I am asking it. So that is a fundamental right. So right to know is a fundamental right. In this, why we all speak about the right to speech and as well as right to knowing. Next line, we will better understanding for this chapter. A bridge between the right to speech and right to know, that is through the language. Language may be English or Tamil or foreign language, anything. Maybe a physical language. Physical language means body language or any sign. Don't take it. Please shut out your mouth. Everything is physical language. So the right to media is right to media means nowadays in our topic is social media, but the earlier stage in the 18th century, media means only the print media. Print media means press. So right to media is a fundamental right or legal right, that is question before me. So right to media or right to press is only right arise from the two rights, right to speech and expression as well as right to knowing. So Article 19 one side, Article 21 another side, that is a bridge, is creating the that is called right to media. The media people publish anyone, anything. So that is called preliminarily, that is called press freedom, come out from the right to speech and expression. You know the very well known case for your ready reference. You know the Nakiran Tamil bi-weekly journal. That is Nakiran Rajagopal is the editor of this journal. He wrote some one article. You've seen it, Auto Singer, Marana Vakamulam. That the book is recorded biography of the famous criminal Otto Sanger. It was challenged before the Supreme High Court as well as the Supreme Court. The court said that very clearly, right to speech and expression include the right to press and press media ensured by the Nakiran Rajagopal state in this book. So right to speech and expression is come out from the right to press or media, come out from the right to speech and expression. That is a first understanding. But then you can understand that first. Then later, press is primary media. Then later it was developed. That is called mass media. Mass media includes, you know very well, cinema, TV, and other things. Any media, mass media or press media, 4 stages of the content is there. 4 stages is there. I give it one by one. I said that you can find it out. One is a collection of news or material. The collection of news or material means, you know very well, NEWS. What is the meaning? Expansion of the north, east, west, and south side. 4 sides of there in the world. We are collecting the news from the 4 sides. So that is called news. That is many proportions there. I don't intervene that. Collection of news or materials. So the reporters collect the news from the various part of the country, various part of the nations, various part of the world, and collected it. That is the first stage, collecting the news and content the material. That's like a research work. Like second stage is called preparation or protection. That is the first stage is called along with press media. The report is there, even news media, TV channel is there, NDTV or so many Republic TV, anything TV is there. The reporters recorded the videos. That is a content, first stage. Second is called preparation. How it is published, that is a preparation. Or otherwise in the mass media, like there is a cinema, protection. Protection manager is there, he is doing some work. How it is collect the story writing, dialogue writing, and everything is collected and recording the cinemas. So that is also a preparation or protection. News materials, including editor. You know the press media, editor name is there, news channel editor, the chief editor name is there, and the cinema, 3 stages in the cinema. One is called pre-production, production, and post-production formalities. So the post-production means the music director making the music, and editor edit the film roll. Now digital world, digital everything is there. And the next 3rd stage is called publication. Publication means spread out. We will make the cinema or TV serial or press or printed the paper, printed the material, everything is there. That is publication is must, for that is a publication spread out. Next 4th stage one is there. That is a very important stage. The publication is limited up to gate of the protection area. Another 4th stage is very, very important. That is called distribution or circulation. You know, the press media people, you asking it, a circulation manager is there. Every Tinatandi or Tinamalar or Hindu circulation. Private manager is the private section. How to circulate it? How many print copies are circulated? How to collect the circulation is going on. In digital TV or mass media, TRB rate, how it is calculated. That is a circulation, distribution and circulation. In the every stage, collection of news, preparation including editing, publication and distribution in the every stage, in the any media, restricted by the government under the reasonable restriction. For example, collecting of the news or content. You know the very well the in Auto Shankar case, our Supreme Court clearly stated that every printed material or document before the court is a public document. You can publish without any restriction. But in old case, one case, you know very well, the Osh murder case. That book is there. Osh murder case is a deputy collector of the Tirunelveli district of, in the British era, 1911. Osh was murdered by the Vanchi station, Vanjinathan in Maniachi station, railway station. In this recording, the suicide note. Suicide note is the court document. But the court clearly stated that it is a primary document for this case. Don't publish it. So the first stage, collect the news. At the same time, the judiciary restricted it. So restriction is there. Article 19, subclass 2. Before independent, without any constitution, the restriction is imposed by the court. What is the court? Court is a part of the state or government. It's the 3rd pillar of the government. So it is restrict the publication or collecting the news. Collect the news is restricted in the collection of news or content. Another stage, the state or government is restricted the preparation and production. You know very well, the cinema is 3 stage: preparation, pre-production, production, and post-production. You know, once again, I stated that. Even the post-production, the censor committee, you know very well the censor committee. If sometime review committee in Bombay, censor committee, every state have a censor committee, review committee at Bombay, edit the scenes, obscene scenes, rioting scenes against the nation. If everything is cut and thrown out, so the film is certified by the censor committee or review committee. A or U. A means adults only. A, U means universally same. So the mass media, maybe a press media or a cinema, is restricted by the stage by stage. And next is, but it's not in the press media because of editing is allowable, but censor is not allowable in the press media, except emergency period. In the Indira Gandhi era, emergency period, press media is under the control of censor committee, of the special censor committee. So news is not published. You can go in the central jails. All news are not allowed to in the jail room or jail premises. Some news are restricted or censored by the prison authority. So censor is there, but limited scope. Another one example, at the next stage, publication. publication of the article or news also subject to suit, I mean civil cases or criminal cases. For example, if anyone publishes the news against the CM or Prime Minister or Governor, is a subject to defamation, avaduru, defamation suit or case filed by the government public prosecutor. So publication stage also restricted by the state or government, state and central government also. Now, the fourth stage, distribution and circulation. You know, one famous case against the Thinathanthi paper, Daily Thandi in Tamil Nadu. Everything is okay. The shareholders of the trust is problematic one. So, one of the trust member filing the case before the High Court and getting a stay in this order, restriction order, don't circulate today's newspaper. It's a very clever idea. As the same thing, I have appeared to so many cases in the cinema area in the year 2004 to 12. I am a practicing advocate in Madras High Court. Once one famous case, one famous cinema also. The director and protection party is a clash between the protection party and the director is a problematic one. At the time, the director asking salary to the protection manager, but he is not given. So we will file the suit in the ordinary city civil court and getting the stay. Don't publish, don't circulate, don't distribute the cinema. Next day, immediately everything is settled and amicably settle the matter in the ADR method. Today is today newspaper is a one thing. There is a lockdown period. All theaters, cinema theaters are closed. So distribution and circulation by the Amazon video, Punmahal Vandal, I think. That is Jodiga and Surya Flame is published or circulation or distribution. That is a fourth stage, distribution and circulation. Circulation means in the press media, distribution through over the online media. Punmahal Vandal is published, circulated. So the three stages are restricted by the, even though the fourth stage also restricted by the government of India or government of Tamil Nadu, state Tamil governments. For another one example, give another one ideal example. You know the one film, New, famous actress Kiran and Simran, and the hero name is, I don't know, I forget it. So that film is very optionable scenes is there. After the censor, after the screening committee or review committee, Bombay, the film was published as distributed and running more than 1 year. But Madras High Court intervened the matter based upon the one petitioner. The throughout all CDs, all basic materials, all film rolls, all digital form of documents in the new film was destroyed by the court order. So another one example, the Kupi, the film name is called Kupi, is very relating to the murder case of Rajiv Gandhi case. That is also restricted by more than a year, more than a decade. That is restricted by the court and government of India. So the distribution stage also, the mass media, cinema, or TV serial, or press, everything is restricted. But we discuss about the social media. The three stages in social media is not identified practically. That is a question includes, for example, Facebook, Instagram, WhatsApp, TikTok, many type of messengers. So that messengers, everything is publication of my ideas, own things. But is the three stages. First one is preparation, my idea, my preparation, my production, I am editing, and publication myself, and distribution, circulation in my own domain, my Facebook ID, my Instagram page, my WhatsApp in the group, my WhatsApp group, in the public view in the TikTok, my ID. So everything is changed in the mass media and social media. How it is law or state break down this issue? That is a big issue before this day. That is a public domain. What is called public domain? we just move it. In the print media or mass media, TV or serial, everything is TV, television, press media, and paper printed, everything is there. A to B, point to point transcription is not a problem. I am sending a message to my lover or my girlfriend, A to B, point to point. It's not a problem. It's not intervene the law. It's a purely privacy. Under the Article 21 of the Indian Constitution, right to privacy is protected. I spoke with my wife or girlfriend or would-be or anything. Don't interfere with by the law or anyone. But I spoke with something related to the sovereignty of the India or anything or otherwise. My girlfriend or wife sent a complaint, sent a police station and lodge a complaint against me. That is a public domain. The case come out from A to B or point to point. Now the WhatsApp is end-to-end description is break down. The third stage is not restricted to the social media. Automatically come out from the public domain. So social media based upon the working in the based upon the internet or web. So that is called working in the cyberspace. Cyberspace. So what is called cyberspace? If no definition nowadays, and till date, no definition for cyberspace. What is called zero? What is the value of the zero? We don't know. The math people very cleverly stated that. What is the value of the zero, sir? Infinitive. Infinitive. வரையறுக்க இயலாது. So the so many governments use that the name Bujisri. So Bujisri means the enormous power. So cyberspace means that is a open to all. That's a public domain, open to all. So no definition at all. Nowadays, law is very keep quiet, silent in this area. Cyber law means cyberspace, no definition. Cyber law is no definition for cyber law. There is an interesting area, you know. He is a very expert in the government, the criminology and criminal law. How to is that so many people, the law professors as well as the criminology professors, the party or advocates practicing in this set, cyber law, sir, cyberspace, sir, but nothing else. It's very simple. What is cyber crime? You can start it from cyber crime. Then we know the cyberspace and cyber law. What is the crime? Don't know, sir. Cyber crime means crime committed with the help of electronic device or electronic gadgets or computer or laptop. Electronic device means including everything. That is called cyber crime. With the help of electronic device in the cyberspace. For example, we have a credit card or debit card, ATM card. One person taken out my ATM card and get it. He got the money? No. He apply the card in the ATM or teller machine, automatic teller machine, and put the PIN number and get the money. So the ATM machine, automatic teller machine, working with the internet connection. That is a electronic device, the automatic teller machine. So that is a cyber crime. The abuse of the card, ATM card or credit card, is a cyber crime. A simple example, that is called simple example. So social media working in the with the help of electronic device in the cyberspace, internet connection. Without internet connection, the social media is not working. Without the electronic device, the social media is not possible peacefully, working peacefully. For example, recently, the Kashmir divided into 3 parts as a union territories. The people fighting for 4G connection, 4G internet connection. Why? We are fighting for a right to know under the fundamental rights under Article 21. The Supreme Court also direct the central government, please consider it, give the permission, 4G connection, allow it. So recently, why you can go to the Kashmir? Recently, our Tamil Nadu government restricted the 4G net connection in the Thoothukudi district in the Sterlite issue. So right to know, knowing that what is the issue going on in the Sterlite issue. So we are connect with WhatsApp, Facebook, everything, private social media, but 4G connection is cut. 4G, fourth generation internet connection is cut. So every social media is restricted by the state without any partiality. At the same time, the bank transaction also cut. That is a different story. Emergency call number is cut. That is a different story. So everything is restricted by the state through the law as a simple government order by the Home Department, Home Secretary. Is possible. So the social media working with the help of two things. One is called software thing, that is called internet connection. Another one is called electronic device, gadgets, cell phones, laptops, everything. So the two things are working together, create this mass media. So cybercrime is a social media, is a part of our lecture. What is the cybercrime? First of all, define the crime. What is the crime? As per the Indian Penal Code, 1860, that is section 40 is that offense, define the offense. So offense is defined. What is the crime? One and the same. That is the synonyms of the offense. So as per the, we will discuss about the not only Indian law, that is the English law, that is the IBC, Indian Penal Code, prepared and passed by the English Parliament, accepted by the English Parliament, the law enacted by the English Parliament. So our India ruled by the British people. The British people ruled more than the 100 and odd states or countries. So that countries is called Commonwealth countries. The Commonwealth countries follow the legal system. Its name is called Common Law System. So we learn the Indian legal system is applicable to Australia, USA, and any country ruled by the British people. So that is three legislation, major legislation control over the social media. You think about the section case laws, I don't interfere with. That is a duty of the law college teacher to the law college students. But very simply, three things is there. Substantial criminal law. First one is, you can write it or note it. Substantial criminal law for further discussion. Second one is called Evidence Act. Third one is called criminal procedure. Substantial criminal law, example is Indian Penal Code. What is the crime? What is the punishment for that particular crime? For example, murder, theft, robbery, extortion. That is a substantial criminal law. What is the crime? Which act is called crime? What is the punishment for particular crime? That is called substantial criminal law. Another one is called Evidence Act or Law of Evidence. That is how to prove it. He is committed the crime. Yes. How to prove it? With the help of evidence law. Another one is called criminal procedure. How to proceed the case? Which judge case try the case and award how to, which type of punishment awarded it? How to execute the punishment? That is the criminal procedure. So the three major criminal laws: substantial criminal law, evidence law, and criminal procedure is applicable to the social media offences or cybercrime. It's same thing in USA, same thing in Britain, same thing in Australia. So don't worry about it. Section is different, but act name is different. But three same laws is applicable. So okay, next we will go to what is the crime? Very simple. It's a negative definition. If no punishment, that is not a crime. If no punishment, no crime. If no criminal law, absence of the criminal law is not a crime. If no intention, that is no crime. The three things. If no punishment, that is not a crime. We know the code of conduct of the government servant, Tamil Nadu government or Kerala government or other government, central government. The code of conduct is only rules of conduct. There is no punishment at all. So that is a crime. That is not a crime. For example, the MBs, MLAs, or chief minister or prime minister, the code of conduct is very clear. Don't purchase the government property. But if you I purchase, I am a prime minister, I am purchasing government property. What is the remedy? No punishment. He is evict from the anything is not a crime. Very simply, is the best example. No criminal law is no crime. So day after before, we got more than bottle liquor. That is a crime. Now there is no crime because of Taskmaster is open. So the yesterday it's a crime. Today is not a crime. If we are criminalized introduced, that is a crime. So no intention. Every crime is a two-part. One is called intention of the human being or accused. Another one part is activity. I give you one example, interesting example from the English case law. The train is started one place to another place is running. The upper berth, two berths is there, upper berth and lower berth. In the lower berth, two girls are sitting. The upper berth, one boy is sitting and saw the two girls without any changing the eyeballs. After the completion of journey, the two girls sent a police station, railway station police station, and gave a complaint. Sir, one person is look like a criminal. He's threatening me. His eyeballs is not rotated. He's continuously threatened me through over his eyesight. So immediately, the policeman arrested the person and put in the medical checkup. It's very simply stated that my eyeballs is rotate, my eyes is very open, everything is clear, but my photosynthetic nerve was affected. The eye not connected with brain. So act is there, activity is there, but I could not understand the visibility. So Tamil சொல்ற பிரசாந்தம் ஐஸ்வர்யா நடிச்ச படத்துல ஒரு அழகா ஒரு படம் ஜீன்ஸ் நினைக்கிறேன். கண்ணோடு காண்பதெல்லாம் கண்ணுக்கு சொந்தமில்லை. I seen it. The activity is there, but I could not understand the scene because of my photosynthetic nerve was affected. So the intention from the brain, the activity from eyes is coordinated. That is a crime. Only my eyes are rotate, eyeballs are rotate, but brain is not working because of the disconnectivity of the photosynthetic nerve. That is, I have no intention. That is no crime. It is proved fact in the England case. So, no intention, no crime. Till dates, till 2000, the year of 2000, in India, no law relating to cybercrime or cyberspace or social media. Very interesting one. Because of, in the year 2000, the law was passed by the Parliament of India, that is called Information Technology Act. So, why we will speak about more than this issue? No criminal law, no crime. Till 2000, anyone commit the crime with the help of electronic device, that is not a crime because of no law. Very simple. Next one is called no punishment. If no law, there is no punishment, so no crime. If law is, I said that there is a substantial criminal law. What is the crime? What is the punishment for the particular crime? If prescribed, that is crime. Otherwise, it's not a crime. So, till 2000, no information technology law in our country. So, no criminal law, no punishment. There is no crime until year of 2000. Later, 2008, the IT information technology was amended and added some new provisions are added. After the 2012, the Nirbhaya case, in addition, some regarding issues are added in the Indian Penal Code, CRBC, and the evidence. This is a detailed area. Is not a time for discussion for the section-wise or provision-wise. So we will spoke about our scope. 2000 IT Act was introduced. 2008 IT was amended. Act was amended. Its provision, especially the 66A of the information technology was amended, added. Amendment means including added, cut through this provision and anything, changing the provision, anything. In the 2013 filed a case, 15 was the judgment was passed out by the Supreme Court. Article 66A is unconstitutional because of it is violate the fundamental right of the Article 21 as well as the Article 19, right to speech and expression and right to life. So 66A is shut down by the Supreme Court. You know very well the Singhal versus Union of India. Shreyas Singhal at the time is a law college student. He's filed the petition. This law is affecting my fundamental right. We are shut down. So the Supreme Court accepts the version and shut down the same. So no intention, no crime is old definition. That is the third part. Old ideology. That is called old. That is called preliminary stage of English criminal law. No intention, no crime. That is continuing the traditional crimes. For example, Indian Penal Code offences. For example, theft. What is called theft? We will discuss later a little bit. But no intention, no crime was removed in the IT Act. That is a very important issue. Because of I have no intention, sir. I am just break down your data. No. Your intention is present or absent. That is not a count. But you are open your others' cell phone, others' laptop. The librarians they understand. In your control 4 or 5 computers there, the student enter with break down the open the laptop or computer or desktop, break down the data. Everything is offense because of intention is not considered for the part of the offense in Indian new generation Indian law, that is called IT Act. Another one is called punishment fixed by the law. In the IT Act, punishment is very different nature. In the ordinary traditional crime in our Indian Penal Code, the punishment prescribed for the prescribed for the maximum punishment up to 7 years, up to 10 years, up to life imprisonment. But in the Information Technology Act, minimum punishment was fixed. Minimum punishment was fixed means if you committed in the first time, minimum 7 years, second time, 10 years, or fine amount. Fine also a punishment. When you first time, 1 lakh, 2 lakh, the multiples of the lakh. How much amount was fixed by the fine? You don't know. You know the one case, Justice Kunka awarding the Bangalore judgment 100 crores. Is possible? Did you have a power? Yes. As the same thing in the IT Act. So you are abuse the social media. The court have more power, award more punishment, or maybe a fine or a life imprisonment as per the schedule of the maximum punishment is scheduled as per the IT Act, or along with the traditional crimes. How it is, sir, along with traditional crimes? We'll discuss later. In this time, I am pointed to another one legislation, Indian Evidence Act. Indian Evidence Act amendment accept the electronic evidence as evidence. Yes, what is this paper, sir? What is this writing? That is a document. I have accepted it. I am judge accepted it. What is this, sir? That is sir. What is this WhatsApp, sir? WhatsApp message, abusive message to my girlfriend or myself, sir. Where is the document, sir? That is a document, sir. The cell phone is a document. Yes, cell phone is a document. The message is a document. Electronic form of message is a document. Considered as a document as per the Indian evidence. That is a very important amendment in the Evidence Act that is accepted by the our Supreme Court also. How it is possible, sir? We will discuss about another one example. Electricity Act. Theft, I think I stated that. What is called theft? The 5 content is there, that is called theft. Visible thing or tangible things or objects. Possession. Move to one place to another place. That is the third stage. Move to one place to another place. Without consent of the possessor. And fifth one is with dishonest intention. For example, I have a cell phone. That is a visible one, tangible one. You can touch and understand that is something, things, object is there. So that is a things, visible thing. There is a brown color, very nice LED screen. Everything is visible. We will touch and understand. That is a thing, object. That phone is myself, Gowthaman's phone. My wife taken in her purse. I am a owner. My wife is a possessor. Through the traveling, I give it a wife having the phone with the purse. One thief taken the phone from my wife's purse, not for myself. My wife's purse, not from my pocket. Whether he is a thief, he is asking it. You are a owner? No. I am a possessor. My wife said that I am a possessor. So possession is must. The thief taken by possessor. One place to another place. The thief taken from the purse to his pocket, put in his pocket. One place to another place. Moment is that. Why we are discuss detailed theft? We will discuss later. Very important area. Without consent of the possessor, without the consent of not the owner, possessor. There is a owner. The cell phone owner is myself, but my wife having the cell phone. Unfortunately, I taken the phone my wife's purse and put it to the other person and give a case. I am a thief. I am a owner, but I am not a possessor. So that is very important. Next one is called with the dishonest intention. That is must. I say what is called offense or crime if intention plus activity, that is a crime. That is a theft. Now we discuss about the data theft. Data theft is an offense? Yes, sir. Under which provision of the which act? We don't know, sir. I have an intention to theft the data. Whether the data is a tangible thing or intangible thing, or visible one or invisible one. I am taking the hardware, I mean drive or CD. I taken it, or cell phone. I taken it. Whether that is a data inside it or not seen it, we don't know. So the cyber crime is totally different from the traditional crime. So intention is throughout by the legislation, through the Information Technology Act. Second one is consent. Without consent is taken an account, move to one place to another place. Your laptop is there, my laptop is there, your mail is there, my mail is there. I am just click out from your data, from your database to my mail, one place to another place. That is called data theft. So something is clumsy. Tangible, intangible. It's not a technical problem. It's an offense under the IT Act. Another one is called before the Electricity Act. It's recently speaks about the Electricity Act. Electricity is a subject to theft. That is questioned before the Supreme Court in the 1980s. The Supreme Court very clearly stated that it's not a subject to theft. Electricity திருட முடியாது அப்படின்னு சொல்லிச்சு. Why? No, that is not a thing. That is an objectable thing. It is not a visible one, intangible. Later, the Electricity Act was passed. Our Supreme Court revisited the judgment, returned the base. Electricity is a subject to theft. Same thing. Our data is also subject to theft after the IT Act, after the year of 2000. After the Amendment Act 2008. So electricity is a subject to theft. As I said, data is a subject to theft. Anything from your social media without your consent, that is called theft. So IT Act fulfill the clumsies and problems gap between the law and science. You are a library information scientist. I say science is a very fast, but law is very lazy walking. Like that in Tamil, say said that புலி பாய்ச்சல்ல சயின்ஸ் போகுது, பட் யானை மாதிரி மெதுவாக நடந்தது அப்படின்னு சொல்லுவாங்க. ஸோ science in 1980s we will discover the computer, laptop, anything, I think hard drive and thing. But we are enact the legislation only in the year 2000 only. So very poor administration of justice in this cyber crime and cyberspace. We will discuss about the another case later. So the IT Act always not independently act applicable. It is always along with the in the Indian traditional criminal law, IPC and other major criminal law. For example, I am defame to one person and defame one person, or I spoke against state under the 124A of the IPC. In the India is not good state. I spoke it. That is against the sovereignty of India. So Indian Penal Code offense 124 is applicable. For A is applicable throughout the digital media, throughout the social media. I am subject to prosecution under the IPC as well as IT Act. So, for example, another law is there, local and special legislation. That is called NTPS Act, Narcotic Drugs and Psychotherapeutic Substances Act. It's a very interesting case. I am aware one case. In USA, one fellow give a prescription to the Bombay shell merchant. He's a merchant, is a drug merchant. He's sent some drugs, narcotic drugs, is a part of the narcotic drugs sent through over the Korean. The NDPS NCB National Crime Prevention Bureau, Narcotic Prevention Bureau arrested the fellow at Chennai. I am appearing this case. So he stated that, sir, everything is clear, sir. The US people send a prescription, doctor prescription with signature. I get received it and downloaded it. I give you a medicine, sir. What is the offense made out? He stated that the e-signature is fabricated. Wrong e-signature. Doctor signature was fabricated. It's not a duty of mine. The merchant simply said that your duty is verification of the e-signature. It's must as per the IT Act. So later he is acquitted on so many grounds, but that is a crime is made out. So signature, e-signature, so very valuable one. You can use signature is verified by the check and everything, and pass the money. It's not only a thing. So another one example, obscene. Take the photo in the Facebook or WhatsApp. Is published. Nowadays, the young boys, playboys, take the photos in the intimacy with the girls, published in the media. That is an offense. With the IT Act, with 295 and other things of the IPC, circulation of the obscenes, since there is 295. Vulnerability speeches against the one group to another group, one religion to another group. That is also an offense under the IBC. Along with the IT Act, that is an offense. So many offenses was considered. CRBC, Criminal Procedure Code. What is the purpose of CRBC, sir? In this issue, time I am pointed to another one interesting issue. The Act was passed. IT Act was passed. Information Technology Act was passed in the year 2000. First conviction passed by the Madras Court. Dr. Prakash, he is a very good doctor, but he is unfortunately punished with the sections, provisions under the IT Act. That is a very, very important issue in this case. He is also lose his medical practice as per the Medical Council Act. So it is very powerful act. It's destroyed your rights. So social media, I handle the social media very consciously. So next one is Kanchipuram Thevanathan case. One Kanchipuram priest, called temple priest, along with sexual exploitations inside the temple. The phone was under the some problem is there. So the mobile mechanic also opened that. He's taken from the scenes, the video, and put in public domain. So the mechanic also a criminal. Abettor is come under the IPC. So I don't know, sir. It's not my video, sir. Any one of the media I publish it, sir. That is not a defense. Also, you have a knowledge that is a crime. You can immediately send to police and report it. Otherwise, you can spread out, sir. That is my friend's phone, sir. I seen it, sir. That's I have forwarded the scene from A to another one person, sir. That is also evidence. Recently, our DGP Ravi, State Tamil Nadu DGP Ravi stated that the downloading the children's pornography, child pornography. The pornography is not an offense. You know, the law is very clear. Pornography is not an offense. Sir, what is that? Pornography is an offense, sir. No, nothing else as per the Indian law. But child pornography is an offense. You can go the new legislation 2012 that is called, namely the legislation, namely the POCSO Act, the Prevention of Children from Sexual Offences Act. This act is very clear that section 15 or 16 and other sections very clearly stated that child pornography is an offense. Ordinary pornography is not offense. Our former Supreme Court CJ, Chief Justice also stated that I am seen the pornography without any friends, with my laptop or cell phone. It's not an offense. But spread out, uploading, downloading, or along with other friends, compulsory to the woman or any girlfriend or any opposite sex, that is an offense. So the law is very simple. You can read out, getting more benefit. Another one is called what is the defense of the these offenses? Consent. Consent. I am intimated with my girlfriend. The photo is taken. I am published the photo without the consent of the girl. That is an offense. But he give a permission. Okay, I am very this criminology we will spoke on bad. Exbadism. I am very pretty girl. Please publish your Facebook. Give it the permission in writing. Otherwise, you are a criminal. Consent is a very good defense for the mass media offenses, mass media crimes, or cyber crimes. So the privacy is breakdown. That is an offense. Privacy A to B or encryption, end-to-end encryption. That is a good defense. I am sending only my girlfriend. The message came to her. Who are you? Interface, third party interface and broken the message. You are a offender. You are a criminal. So you know the Facebook, the option is there in the our story, your story or publication to the public or anyone, seen the anyone, the photos applicable to the only me, videos only for a particular friend or friend circle or except that friend. Everything is optional in the Facebook. So you give a consent. The terms and conditions of the social media is there. So we will very simply take a mouse and click it. Yes, 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 yes. Okay, 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 okay. Finally, one case is that. What is that, sir? The Facebook abuse my data, sir. You give a consent, sir. You give a consent, madam. Every terms and condition is read out. No, nothing else. Is our friends are said that yes, 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 yes. The Facebook have some condition is there, regulation is there, rules framed is there. The Facebook operated from USA. You are in India. How this law synchronization, sir? Indian law is applicable or American law is applicable? The conflict between the jurisdiction is possible in the social media. So you can first turn on the any social media. You can read out your terms and conditions. Otherwise, you have no right to sue or file the case against the public media or a database. That is a problem. Second one is called regulation. Which regulation is possible? Our recently Zoom, it is a meeting app, but it's a venerable one. Our Supreme Court hearing, our government of India said that. So avoid the Zoom. So you are not entertained, voluntarily entertain the Zoom meeting. Police people also entertain the Zoom meeting. If anything is spread out in the news, so you are liable because of the government of India. UGC also prescribed that Zoom, avoid the Zoom. Recently, you know very well the UGC circulation. So everything is a vulnerable one. You can point out, read out, and understand it, and then you can use the apps and other data. So another one is point to the judges or attorneys, the advocate is very, 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 very little bit idea in the cyber crime as well as the cyberspace and social media. Recently, our Supreme Court heard the Aadhaar case some months before. One senior advocate stated that Aadhaar data is very safe, my lord. Don't worry. We save the Aadhaar data. Judges asking once again, How it is protected? The senior advocate stated that we protected with the 13 feet concrete wall. You know, I say the attorneys, judges, or the people relating to the courts or court officers, lesser knowledge in the cyberspace or cybercrime. Yesterday, I am in Chengalpattu, nearby Kalpakam is there. Kalpakam atomic reactor protected with 15 feet concrete wall is applicable, is acceptable. Because of a reaction, every reaction, this chain reaction is protected with the concrete, heavy metal concrete wall. Yes, okay, accepted. Whether the data are protected with the concrete wall, you know, what is the mindset of the people in the legal fraternities? So, very clear that the legal system and the Indian law is there. Law is very powerful, but the attorneys, maybe a government or defense or judges, the court officers have a little bit knowledge in this issue. So the judicial system is a lesser idea in this issue. So you have a right to protect yourself. I think Suresh sir conclude பண்ணா like 1.5 hour ஆச்சுன்னு நினைக்கிறேன். I think 4 slogans for you. Isolated from the society. Keep distance from the society. Stay home. Stay your home. Isolated from the society. Keep distance from the society. Stay your home. Stay safe. It's not only for Corona. Isolated from the society, cyber society. Keep distance from the public domain. Stay your home, not the other home pages. So stay safe in your own domain, not for the public domain. So thank you one and all. Thank you for this opportunity to the Madras Librarian Association as well as Suresh and Tirunavkar. Thank you.
Thank
Sir,
you.
please be online. We received 5 more questions from the participants.
Yes. Welcome.
One is, what is the relevance of Section 22A of Indian Evidence Act in a criminal case?
22A. I am not encyclopedia. I have a book and refer it. I give it the answer. Okay, within 2 minutes. Okay. 22A. Everything is a section, but there is just like a reference of the page of the books. Because of I am a little blind, as like a Barrett.
Okay, so can we go to the general question, sir?
Yes, please wait. 21. Please, I give you answer first
Okay.
one. When oral admission as your content of the document are relevant, yes, that is a oral evidence. If you have a data for hard drive or hard disk in the electronic evidence, you are a securing person. Yes, அதில் இருக்கிறதெல்லாம் உங்களுக்கு தெரியுமா? Yes, you know about the hard drive and activities of the hard drive and data based upon the hard drive. I am asking the question to you, so you give you an answer orally. That is article section 22 of the Indian Evidence Act.
Okay.
Ensured data ensured by the oral evidence. Yes.
The next question, sir. What is an evidentiary value of the printout of an email?
I think before I answer, please introduce you.
Sir, I am Tirunavkar, sir.
Tirunavkar, yes, very good. Printout of the email is valuable.
What is the evidentiary value of the printout of?
Yes, it's acceptable, but countersigned by the printout man. For recently, one case like that in the Bombay High Court judgment, the judgment is possible only after the certificate copy is valuable. In the meantime, the Bombay High Court uploaded the judgment through over the internet. So the judgment was downloaded from the internet and give the concerned authority. the authority is not accepted because of it is not properly drawn, because of it is not certificate copy. But Bombay could state that it's a acceptable, allowable one, but signed by the particular advocate or the person. So you can take the printout from the email. You can countersign by Tirunavakarse, by Suresh. That is valuable. Otherwise, it's not valuable.
Okay.
Okay.
That's all, sir. Suresh, sir.
Okay.
Gautam, sir.
Yes, சொல்லுங்க.
One more question from participant Surabhi.
Yes, welcome.
How the examiner of the electronic signature certifies of the electronic certificate attached with the prosecution case under section 47A Indian Evidence Act.
47A.
Yeah.
Indian Evidence Act is a very simple legislation, not for more than 151 sections. At the same time, 46, I think, repeated the section?
47A.
47A. Yes, 47A. Opinion as to electronic signature. That is an expert opinion. Sometime, for example, give a signature. Ordinary documentary paper is there. Ordinary documents. Whether the case is come, the property document, whether the signature is a signature, original signature is a expert opinion is recorded, and then we will consider, the judiciary consider the false order. As the same thing, the electronic evidence or electronic signature is send a opinion, give a the document sent to the opinion from the expert, the office of the expert. May be accepted, may not be accepted. It's a discretion of the courts. Okay.
Okay, sir.
That is evidence, but may be accepted, may not be accepted. It's a purely discretion of the court. Expert opinion is not a valid one. Secondary evidence. That is called secondary evidence.
Suresh, sir.
Yes. Any other questions, sir?
I think Suresh lost connection. Sir, another question, general question. Money is stolen through ATM card. How to recover it and procedure?
That is a procedure is different from one bank to another bank. You can immediately call for the toll-free number or mail ID and restricted that and send a complaint. And the complaint was registered within a week. Rectify redressal form is with the help of the computer or a camera, CCTV camera, and rectify it and give it. Otherwise, it is a police station complaint is recorded as per usual ordinary procedure is followed.
Okay, sir. Thank you. Suresh, sir, are you online?
Yes, yes.
சொல்லுங்க வேற ஏதாவது क्वेश्चन இருக்கா?
இல்ல இல்ல. வாட் ஆஃப் தேங்க்ஸ் சொல்லு.
நீங்களே கன்க்ளூட் பண்ணுங்க.
நீ சொல்றியா?
நீங்க சொல்லுங்க சார் பேர்ல சொல்லுங்க.
ஓகே சார். Sir, thank you very much for a wonderful webinar series. This was more informative and interesting one. You explained everything in the Indian Criminal Law, Indian Evidence Act, and the IT Act, everything you have elaborated. First of all, thank you very much. You also discussed with some examples that was very useful to us. Once again, I thank you very much for the behalf of participant and Lisquiz.com and Meta Cyber Association. Thank you very much, sir.
Thank you.
So I already received 250 registration, sir, and the feedback. 99% very much appreciated about your presentation.
Okay.
Thank you so much.
Thank you one and all. Thank you everyone.
Thank you, sir.
Thank you everyone. With this one, we will conclude this session. What do you